Day 5 of Texas versus Aaron Dean. Both the state and defense have rested their cases. The state did a rebuttal and rested their entire case. Now, tomorrow, the jury will get its instructions and then closing arguments will begin. Now, Dean is a former Fort Worth police officer charged with murder for shooting Atatiana Jefferson in October of 2019. Experts for both sides took the stand today, and who the jury will believe, I don't know. Now, they're scheduled to begin deliberations tomorrow. Here with our debrief is Court TV legal correspondent Julia Janae. Julia is joining me now in studio. All right. The defense today called a police training expert. All right. So what did we learn from that expert? Can you tell us?
We learned a lot. I mean, that's really at the crux of this case, because though we know he's arguing self-defense, saying he feared for his life, the reason he was on the property of another is because he was a law enforcement officer. And this prosecution says that Aaron Dean failed at handling this in the appropriate way in terms of police protocol. So having Jay Coons on the stand, major for the defense. And he was a great witness. He really took these jurors through the book, what police officers are faced with, what they are told they have to do, and even telling them the difference between what they should do and shall in some of these guidelines. Shall meaning they have to, under no circumstances, do something different, but should meaning it's a recommendation depending on the circumstances. They also heard him talk about the amount of time that this officer took in his assessment, really slowing down this body camera footage that to a viewer can seem to have happened in seconds, 1 second, a millisecond. Take a listen to Coons talking to this jury, and we understand that they were taking a lot of notes during his testimony.
When he takes this deep breath, you can see his thumb goes off the momentary switch on the flashlight, and he straightens his body up. At this time, it looks as though he's moving slightly backward and he's drawing his weapon. So this is one OODA loop. He's made an observation. It's a figure in a window. What's that figure doing? It's bent over at the waist and it's reaching for something. He's wondering what that is. He doesn't know. So he makes a decision.
And this expert was very clear in the outcome or the opinion that he gave to this jury through the defense. He first talked about the amount of experience this officer had and how that weighed into his opinion. Take a listen.
Based on in calculating reasonableness for this,
yes,
you have to take the two rookies as they are. Darch isn't on trial, so you have to take Dean as a rookie. You consider him a rookie at that point?
Absolutely. He only had a year on the street.
Do you have an opinion as to whether or not Officer Dean's actions that night on October the 12th, 2019 were reasonable based on your understanding of the use of force standards and the ability to defend himself against a deadly weapon?
Officer Dean's actions that night, and yes, this is a terrible event. There's nothing good about this. But his actions as a police officer were reasonable in what he was doing.
Reasonable from that expert. Michael, that was the last witness that this jury heard from the defense before they rested.
Yeah, you know, I wondered if the defense had some other witnesses, but that witness went so well that maybe they decided, let's just end it here.
We've seen that happen.
We've seen that happen, so I was wondering if that was the case. All right. Now, there's been an issue. We heard a lot of description about this call and how it was responded to and the terms that are being used to describe the place, the home where they went to. Tell us about that.
Right, and that conflict could come up big inside of the deliberation room, because jurors are going to have to look at not only that protocol, but why Dean acted the way he did when he actually went to the home of Atatiana Jefferson. We've seen that body camera footage of him circling, and we know that the 911 call, the neighbor called it a welfare check. We learned yesterday it's possible the officer did not hear it as a welfare check, but rather an open structure. And There's been commentary here on Court TV about what that really means. Even some of our law enforcement experts saying that an open structure can mean that this is a business or a place where people aren't expected to be when it's the middle of the night like this was. But this is a dwelling, this is a home, and the prosecutors are tasked with making sure the jury understands that there should be a certain expectation of people being inside when there is a home. This expert today said that whether you announce or don't announce, in this case, Dean did not announce, but he said that can come down to where they are. Take a listen.
In Texas, under TCOL and under the training that Fort Worth utilizes, is mere presence alone sufficient to identify somebody as a peace officer?
Mere presence alone,
Police officer in uniform as Aaron was that night.
yes. In uniform, yes.
So the misnomer in the media that they have to identify themselves, that's not what the orders say, is that correct?
No.
And that's not just Fort Worth's orders, that might be Denver, Colorado's orders, the Department of Justice's orders. If there are times where officers are faced with deadly force as soon as they walk up on something, is that correct?
That's correct.
Now, if jurors believe that he did not need to announce, that goes to one of those police protocols that the prosecution says he did not follow. This expert saying he would not necessarily have had to follow that in this situation.
Yeah, it was very interesting and good testimony, definitely, for the defense. Now, we had been wondering, where was the state expert? Well, on their rebuttal case, once the defense rested, they called their expert. Explain to us what he had to say.
They did. They called a forensic analyst, someone to kind of rebut what we were hearing from that expert. It's the way they rounded up things in terms of we know their case in chief was at the beginning, and this was their rebuttal case. So someone who was able to pick apart a bit of what this expert did, though I think having a law enforcement training officer was a lot more powerful for this defense there on the stand. Not exactly the strong ending that I expected from the state. Not that they didn't lay everything out in their case in chief, and they get a chance to wrap everything up in front of this jury when their closing arguments happen tomorrow.
Yeah, I agree. I think that might have been a bit of a weakness in that rebuttal case. And they, on the defense's case with that expert, they went through various, code thing, the protocols. They didn't do a lot of that on the state's case, so it was a little bit questionable. Julia Janae, thank you so much for that. I truly appreciate it. Let me bring in my guest for this hour. Joining me is trial attorney and former federal prosecutor Gene Rossi. All right, Gene, today really shaped up as a battle of the experts, the way it worked out. You had the defense's expert take the stand. You had the state's expert take the stand. Your thoughts on who might have won that battle today?
Okay, just saying that it's a battle of the experts in a criminal case, in my 30 years of experience, that's not a good compliment. That's not a good comment. When you have an expert like the one that the defense used to rest their case, and Mike, I think you're right. I think their expert, the defense's, was so powerful, so convincing, had the jury taking notes, captivated the audience. They may have had other witnesses, but they say, let's shut it down. We ended on a high note, and let the government try to match that great expert I'm looking at him right now. I think he was on a scale of 1 to 10, he was an 11.
Yeah, I'd have to agree. And Gene, when it was all said and done, I sat there in my office after watching both testimonies, and I said, I'm confused right now. I'm not sure exactly what these officers should have done. But if I was going to choose, I would have chosen the testimony of the defense's expert. And if I'm a juror, or if I'm the defense, that's probably a good thing, because what I can honestly say is that in listening to the two of them, I had some reasonable doubt about whether the state had proven their case.
And here gets to the burden of proof. And if I were the defense attorney in closing, I would pound that. Because if it's a battle of experts and there's a juror that says, you know what, maybe he was likely, possibly outside the reasonableness of being an officer, but you're going to have people in that jury room that are going to be advocating for that defendant. I guarantee it. Yeah. And the reason is he's a rookie. That struck me as very important for this expert's determination, a major factor. He's a rookie. He didn't have to announce. He thought he saw someone reaching down for a weapon. If you're a rookie, your blood pressure and your pulse are going to hit the roof. And I think these jurors are going to cut him a break. In a criminal trial, looks like it could be guilty or hung. In a civil case, if this were a wrongful death suit, a little different.
Yeah, I agree, because when I look at this, one of the things that I take away from this is the state's expert came up and said the two reasonable things for these guys to do is what made sense to me and our experts here at Court TV. Former police officer Joe Ested is on our staff here, saying when you come up to an open dwelling, not an open structure, which they kept using those terms, you come up to an open dwelling, you see cars in the driveway, first thing you do is you either secure both exits and call for backup, or you knock on the door and announce. That's what makes sense to me. If the protocols say that it's okay to do what these officers did, then I think there's an issue with the protocols. But if right now the protocols are right, you're not going to get a guilty verdict.
Absolutely. And Michael, here's the other thing. That crime scene, alleged crime scene, is just a total mess. And he's doing what he called an open structure, what he thought in his mind was an open structure, not a wellness check. He doesn't know if there's activity, drug activity in there. Could be we don't know. And it's not a pristine house where he had a driveway and a cut lawn. This was something that he had to sort of surveil before he made a determination of the next option. That's why the argument that he had to announce that he was an officer and he was there, I don't buy that.
Yeah, it's a tough one, and I wrote down in my notes as I was watching this new variable of the when you determine reasonableness, you have to remember that he had only been on the job for about 18 months and was a rookie. I think you mentioned it earlier. I think that was a big deal. I think that was a big deal, definitely. So we'll have to see. They'll be getting the case tomorrow, so we'll have to.